Hello friends, in the series on the income tax matters or income tax cases, the issue which has been taken by us in the present case is that there is a lot of importance of the compliances which the assessee has to done in the Income Tax Act, and that compliances should not be delayed in a casual manner until and unless there is some urgency for the assessee to delay those matters. The name of the present case is Jayshree versus Central Board of Direct Taxes and others, and this case has been reported in 464 ITR at page number 81, and the matter has been decided by Honorable Madras High Court. The date of the judgment is 3rd November 2023. In the present case, the assessee is a female assessee. The matter relates to the assessment year 13-14. The assessee had purchased a property in 2006 and sold this property in 2013 and again invested the amount of the sale of the property into the fresh property. But the assessee filed her income tax return in the year 2016, meaning thereby that the assessee has not filed her return of income on time, due to which the department initiated prosecution proceedings against her. When these prosecution proceedings were initiated, the assessee filed the compounding application in 2021. When the revenue gave the hearing for this compounding application, they rejected this application by saying that there is a circular of the Central Board of Direct Taxes dated 14th June 2019, which says that the compounding application has to be filed by the assessee within 12 months. And by holding that, since the assessee has not filed the application within 12 months, the compounding application of the assessee was rejected. The assessee was having no option other than to file the writ, because now it is a matter of going to the jail for the assessee, because the assessee has to face the trial. So to escape that trial, the assessee was trying for the compounding. But the compounding application was rejected, so the assessee filed the writ in the High Court by saying that my compounding application should be considered and it should not be rejected outrightly just because of the limitation period. When the Madras High Court heard the matter, the Madras High Court was of the opinion that according to section 279, there is no time limit for filing the compounding application, and the compounding application can be filed either before or after the initiation of the prosecution proceedings. Madras High Court also said that there is explanation to section 279 which says that the revenue can issue instructions, various circulars for the better implementation or the proper implementation of the act, but by that circular, the Central Board of Direct Taxes is not empowered to amend the section 279 by limiting the period of filing the prosecution application. So the Madras High Court in the present case quashed that portion of the Central Board of Direct Taxes circular dated 14th June 2019, which talks about the limitation period of filing the compounding application by the assessee within 12 months. The court said that in the present case, fixing time limit is contrary to the intention of section 279, and it amounts to amendment of section 279, which the Central Board of Direct Taxes is not empowered to do by issuing the circulars. Friends, this case is very important according to me, because although the Madras High Court quashed the rejection order of the condonation and redirected it to the Central Board of Direct Taxes by saying that it should be heard on merits, my point is that so much of the harassment can happen to the assessee by not filing the returns on time, like in the present case, that the prosecution proceedings are started against the assessee, his compounding application is not accepted, and then the assessee has to move to the High Court for just that my compounding application should be heard, because even if the compounding is done, then the assessee has to pay the compounding fees also. So friends, this case is very important and it gives light that the assessee should not take lightly the period of filing the returns of income. The returns of income should be filed on time. At the end of this video, once again I am repeating the name of the case. The name of the case is Jayshree versus Central Board of Direct Taxes and others, and this case has been reported in 464 ITR at page number 81, and the matter has been decided by Madras High Court and the date of the judgment is 3rd November 2023. Thank you friends.